Welcome, be seated. Good morning. First of all, thank you to Mitchell Hamlin and to Holly Pearson for inviting us here to conduct oral arguments today and for the accommodations. The case now at hand is file number WC 246591, entitled Jolie Johnson versus Provide Care, Inc. As you will see, we have a 3-judge panel. We have Judge Sean Quinn, Judge Tom Christensen, and myself, Judge Kathy Carlson. To counsel, I want to thank you both for agreeing to be here today. It's part of our mission to make sure that we engage with students in the bar to give them a glimpse into workers' compensation, the appellate practice. So I know that this is a special favor to us and we do appreciate it. I also know that you're both alum to what is now Mitchell Hamlin. So again, thank you for being here. The timing rules are as follows. You each have 15 minutes total for your respective arguments. We will give you 3 minutes of uninterrupted time to present your argument, and then you will be asked to stop to see if the judges have any questions. Appellant goes first. You may reserve as much time for rebuttal as you wish. It is up to you to keep track of your time. And at the end, the marshal will put the remaining amount back onto your clock. Also, so that you are aware, we are both recording and live streaming this argument. So we ask that you project your voice if you can and speak up. Finally, after oral argument, we will stick around to answer any questions from the audience. We can't talk specifically about this case, but we're happy to talk about anything else. With that, Mr. Hines, you may begin.
Thank you, and it may please the court, counsel. Welcome, visitors. My name is Scott Hines, and I'm here on behalf of the appellant employee, Jolie Johnson. And in the context of doing oral argument, somewhere back in law school, we were told, don't stand in front of learned court and read your brief. So I want to tell you 3 justices something about Jolie Johnson, which is part of the record, but has not been maybe fully explained who she is. So for example, at age 52, she was 56 at the time of this injury, but at age 52, she and her husband met a young lady at a prayer meeting, and this young lady was pregnant. They had met her before in this context. She was a drug addict. So what self-respecting, knowledgeable 52-year-old with adult age children would adopt a child at that particular age? That's the kind of person she is. I know I am not the only grandparent in the room. And when I've had the blessing of taking care of, I've got 5 of them, somebody always says something like, well, that's why we have them when we're young. So Jolie and her husband, David, took on this particular child who is a mixed race, and they are caring for him, and Lucas is now 4 years old. They literally received him hours after he left the hospital. So that's who Jolie Johnson is. Also, lost in all the different details that you've read and you've heard and you've seen the transcripts about the job and how she got hurt. Go back and dig one step deeper as to the employer itself. They own homes where people who cannot live on their own reside. So who is Jolie Johnson? For about 15 of her employment years, 5 of which in 2 different shifts were with the same employer, she helps people who cannot live on their own, whether it's a physical handicap or a mental disability reason. That's who she is. So that's part of why she goes into that kind of work, is she's a people helper. So then you also, because you've read what both counsel and I have submitted, you know that she had a history where she had some low back complaints. So for about a dozen years before this injury happened, she was conservatively managing problems with her low back. She had been employed at this particular location about 2 years on this shift before she got hurt. And on March 26th, and I know that there's two different dates that are listed. Sometimes it says the 24th, sometimes it says the 26th. I believe the right date is the 26th. We did talk about this at hearing, and it isn't terribly relevant, but so on the 26th, one day before.
Mr. Hines, I'm going to stop you there just because we have this thing now where we do 3 minutes.
Okay.
And I just want to see if any of the judges have questions before you continue.
Mr. Hines, first of all, I don't know if it's me up here, but I don't know if your voice is projecting into the microphone. So, the people in the back say they can't hear you. So,
And we do have some fans blowing up here too.
yeah, but
I will stand closer.
okay, give me. I mean, you're the appellant. You have the harder burden here at the Court of Appeals. Give me your, maybe a 1-2 minute summary, your best case for why we should reverse the compensation judge.
Thank you, Justice Quinn. The best reason is the before and after medical records and work record are very black and white different. Before she got hurt, she had been treating conservatively with United Pain Center for about 10 years. But at Thanksgiving time of 2023, 4 months before she got hurt, she went in to see her nurse practitioner at United Pain Center, and they have this disability index, and 0 to 100, hers was 29 out of 100 on that date. And her subjective 0 to 10 pain scale was 5 out of 10. She was working 46 hours a week on average based on the average weekly wage and the earnings that she had. She had no restrictions. She had not seen her chiropractor that she had treated with for previous work injuries with this same employer for 32 months. When she gets hurt, it's on a day when there were 6 to 12 inches of wet, heavy snow. So 56-year-old lady with some back issues goes outside because she had to take care of the sidewalk. She didn't have to deal with the driveway, but it's a home where these individuals live, and she's the manager of this home. So she goes outside, uses a metal snow shovel. She said it was her estimation 15 to 20 feet long was the sidewalk, and she called it an average width sidewalk. I'll say 3 feet, but I didn't measure it. So she goes out and she moves that snow 2 different times on March 26th, about 2 hours apart. And by 7:30 that evening, shift started at 3, she noticed pain. She reported the injury the next day. So that's one choice and ever since then, it's been 13 months since this injury, and she remains off of work. The other choice that the court has is the opinion of Dr. Paul Wickland. Dr. Wickland eventually, as he reviews all.
Mr. Hines,
Yes.
because I want to talk about Dr. Wickland. Do you feel that Dr. Wickland had adequate factual foundation for his report?
Dr. Wickland checks boxes to make it appear that way. My analogy, Your Honor, is this. He had everything in front of him to say that he had adequate foundation, but I do not believe that he read objectively the records that from which he draws his conclusion. He did not see a September 9 visit and then the report from her spine surgeon, Dr. Maybod, Mehbod. So he never saw that, at which Dr. Maybod said, yeah, this snow shoveling incident definitely increased her symptoms. He had seen Jolie Johnson 12 years before that for a low back consultation, and at which time he recommended managing conservatively.
So you agree that Dr. Wickland had the facts in front of him other than Dr. Maybod's report because it did not exist at the time of his exam, but you feel that he just didn't look at the records objectively. Is that a fair summary of what you said?
It's a fair summary of what I said so far, but I have one other record that he did not have.
Okay.
So again, when in November of 2023, she went to see United Pain Center. She also, her next visit to United Pain Center, which had been scheduled, she goes every 6 months. She saw the same lady, Una Edwardson, a nurse practitioner. And the week before she was seen by Dr. Wickland, she came back there And the contrast is stark. So back to Justice Quinn's question, this visit on, I think it was the 29th of May, 2024, her pain index went from 29, more than double, up to 63. And then her pain scale, 0 to 10, was 9 out of 10. She was given a handicap pass for parking, and she was prescribed a cane. She was prescribed to go to Reyes for the possibility of consultation on epidural steroids. And at the time she saw Dr. Wicklund, then about a week later, she didn't know of the things on surveillance that had already, transpired by that date. So she was already dealing with these symptoms, and that was the exacerbation. Now, did I answer your question, Justice Carlson?
You did.
So in reviewing the facts in your argument that you've just made, Mr. Hines, we're still dealing with a substantial evidence as our standard of review, are we not?
Yes, sir.
And then second of all, I mean, you talked about the surveillance, and one of the, obviously the compensation judge gets to determine the facts, and if there's substantial evidence in the record to support that, then we affirm. And in reviewing the findings and order of the compensation judge, at least in my review, it looks like the surveillance detracts from some of the statements you made, because the surveillance shows that the employee was walking, standing, sitting, driving, and carrying, and at the same time was seeing the chiropractor, Dr. Anderson, and saying she couldn't do those things. You have a reason, or why should we throw that surveillance out that we can see for ourselves and accept that your client couldn't do things as set forth on the pain disability indexes?
Does the court actually review the surveillance?
Yes.
Yes.
Thank you. That's good.
We
Because
have the report and the video.
okay, what I would say is this: you will not see her doing brisk movements. You will not see her lifting anything over the 10 pounds that her chiropractor limited her to at that particular time. You will not see her moving fast. You will not see her doing anything but deliberate, calm walking. And then as you review it, at the end of the first day of a video, what you will see is she gets home and she's got bags from Walmart, and she walks up outside steps, 3 steps outside that were on surveillance. She walks up very carefully, one step, and it really is evident that she has the kind of symptoms that she has in that particular part of the video. So, Your Honor, Justice Christensen, I believe that the video does not prove that she had the ability, but she remained disabled, as her doctor said. And then she testified throughout the summer, and her husband did as well at trial, that her symptoms got worse after that.
But the video does show her like on her feet, standing, walking for about an hour and a half. And she's telling her chiropractor 10 minutes is my limit. So, I mean, isn't that what we're seeing?
When she was inside the Walmart,
Yeah.
she had the cart.
Yep.
So she was using that at times. And then again, she testified that, yeah, nobody saw when I went back home and I had ice. So that's her response. And that's all I can say. I obviously was not there.
Counsel, I do have a question about, you had talked about Dr. Maybod's November 2024 office note.
No, I'm sorry, that was Una Edwardson at United Pain. Maybod was in September.
September. Okay. Yeah, I'm sorry. September of 2024. And he had made the statement that the incident at work significantly worsened her symptomatology. Is that what you're relying on as support for your claim, Dr. Maybod's report, in addition to the United Pain Index?
And the chiropractic records, Your Honor, yes.
Okay.
But again, I think that one, because it was unsolicited by me, I didn't ask him to write it. It was just what his record showed.
Well, do you believe that Dr. Maybod, did he have an adequate factual foundation for, assuming we call that an opinion, did he have adequate factual foundation for his opinion?
he had seen her 12 years before. He recognized that she's definitely worse. And I guess he took as believing her statements.
Had he reviewed the United Pain Center records or the chiropractic records or the surveillance report?
He had not.
I have a totally different line of question. You know, and looking at your notice of appeal, you appealed a number of factual findings. And the ones that I want to bring to your attention are 5, 28, and 36. And the reason that I'm asking about those three is they appear to be, in my review, a recitation by the compensation judge of, you know, well, for example, 5, the employee treated with the chiropractor in 19, 20, and 21, and said various things. Are you disagreeing that, well, is there a disagreement that that's an accurate recitation of what those records say? I guess that's my question.
Well, on my copy, Your Honor, I circled the word regularly because it made it sound like she was treating at that time as
Okay,
often
so
and as
regularly.
frequently as she eventually has since, well, had. She's not there at the moment.
Okay, so
That makes sense.
that answers my question on 5. What about 28 and 36?
So 28. I circled that because that was one of the things where she was having pain and she would have pain for standing, but she had to do things. So that's why I wanted to bring that to the court's attention. And I don't quibble with the accuracy of what the chiropractor's records said.
Okay, and would you say
36?
36? That's the text message string with her employer.
For the most part, when I cross-examined Ms. Gregg, I said she never did say she was not coming back at all, correct? And I believe that she agreed with that. And then to some extent, Your Honor, depending how you rule on the word idiopathic that Dr. Wicklund has versus that the snow shoveling incident may have made her prior symptoms worse, it's fairly irrelevant whether she resigned or not. If she has the problems she had, and Dr. Wicklund's report is taken off the table by a reversal of this court, I really don't think that particular resignation or not makes much difference. Now, I know I've been told to sit down.
I just want to see if there's any further questions.
No, I don't
No.
have any.
Okay, thank you
No.
very much.
Thank you.
Can people in the back hear? Is everyone okay? Okay, thanks.
Morning, Your Honors, Counsel. May it please the court. The sole question on appeal today, really, as Justice Christensen's alluded to, is whether there's substantial evidence in the record to support the findings and order of the compensation judge, which found that the employee sustained a temporary aggravation of her pre-existing condition in March of 2024 and granted the petition to discontinue temporary total disability benefits. The findings and order are supported by substantial evidence, and the respondent, employer, and insurer respectfully ask that the court affirm in all respects. Consistent with the law and the longstanding precedent of the court, the findings of fact should not be disturbed unless they're clearly erroneous and not reasonably supported by the evidence as a whole. It's within the sole discretion of the compensation judge to review the entire record as admitted and choose between conflicting medical expert opinions. This court normally will uphold the compensation judge's choice among medical experts, so long as the facts assumed by the court are supported by the record and the medical opinions do have adequate foundation. And any foundational objection that would need to be made at the hearing level. The employee can't raise that for the first time here today on appeal. The record reflects there were no foundational objections raised by the employee at hearing to Dr. Wicklund's report. And the employee stands here today and raises some issues with Dr. Wicklund's qualifications to offer expert medical opinions. However, any of these issues regarding Dr. Wicklund's qualifications These were appropriately weighed by the compensation judge at hearing, and they were soundly rejected. The record, when carefully reviewed as a whole, demonstrates that the employee does have a significant history of similar prior treatment going back at least until 2012. And the record demonstrates that she did have an increase of symptoms after she shoveled at work. But the record also demonstrates that the employee's post-injury symptoms were the same or similar to the symptoms experienced prior to the shoveling incident. Now, while the employee may have temporarily aggravated her pre-injury symptoms, the overwhelming evidence that is in the record supports Dr. Wickland's opinions as to the temporary nature of the employee's injuries. Dr. Wickland is the only doctor in this case to have reviewed all the medical records and imaging, both the pre and post-injury records. And there's no evidence in the record suggesting that the employee's treating doctors, including Dr. Maybot in September, had complete histories of the employee's prior relevant treatment. The compensation judge's findings and order reflect that she did carefully consider the medical records. The compensation judge also carefully considered the employee's testimony, surveillance evidence that was previously discussed, and the employer testimony in exercising her authority to choose Dr. Wickland's opinions over the opinions of the treating doctor.
Thank you, Mr. Schmidt. We're at 3 minutes, so we're just going to see if there's any questions.
I'll ask you the companion question that I asked Mr. Hines. In a couple of minutes, give me your absolute best case scenario why we affirm.
The reason to affirm this case, this is a very straightforward Nord v. City of Cook case. And so this is a situation where the compensation judge was presented with essentially two different medical opinions that differ with respect to the nature and extent of the employee's injury. So you've got Dr. Wickland's opinion, as I mentioned earlier, very clear that the employee either didn't sustain a new injury or that the injury itself has resolved and she no longer needs restrictions. The opposite side of that is the records that, as Mr. Hines has alluded to with respect to United Pain, as well as Dr. Maybot, indicate and the chiropractor indicating that the employee continues to have restrictions. There was adequate foundation for the opinions of Dr. Wickland. Those were adopted by the compensation judge. And again, when this court is presented on appeal with that issue of substantial evidence, the court normally will defer to the discretion of the compensation judge.
Mr. Schmidt, I'm going to interrupt you for a second. You've said a couple times that the compensation judge adopted the opinions of Dr. Wickland. But in fact, what she said is she finds them more persuasive. And actually, one of her findings was not consistent with Dr. Wickland. Dr. Wickland actually found that there was no injury, correct?
Correct.
And the judge, in fact, found that there was a temporary injury that resolved as of June 4th. So the judge did not wholesale adopt Dr. Wickland's opinions. Do you agree with that?
I do agree with that. She didn't wholesale adopt those opinions. I think the case that I would just bring to the court's attention would be the case of Clausen versus American Linen. That's a 1994 Work Comp Court of Appeals case. And in that case, the precedent that comes out of that case is that the compensation judge can adopt or reject any portion of the IME opinion or any medical record that they're reviewing. And in this case, you are correct, Your Honor. She did not adopt the portion that an injury wasn't sustained. She did adopt the portion with respect to that the employee did not need restrictions.
So let me tell you what my concern is. Mr. Hines actually makes a very good point here today and also in his brief that the medical records are pretty clear that her symptoms and her ability to work became worse after the injury. And the judge finds that the temporary injury resolved as of June 4th, the day of Dr. Wickland's report, and that there's no specific support for that because, again, Dr. Wickland found that there was no injury. So what evidence is there that a temporary injury resolved as of June 4th of 2024?
Well, I think I would just point out to the court again, the surveillance evidence that was reviewed. I do think the surveillance evidence is very telling in this case. And as I did, the judge highlights it in the findings and order, and I put it in my brief as well. It is very clear as of May, she's telling Dr. Anderson, her chiropractor, one thing about the symptoms she's having, the level of disability that she's at in terms of what her physical abilities are. And then it doesn't show up when you look at the video. And it is a very telling video. I think Justice Quinn alluded to it. There's hours on end of her, walking around Walmart, shopping at garage sales, things like that. It doesn't match up with the history that she is providing to both Dr. Anderson as well as Dr. Maybot as we get to September.
The surveillance does show her, as Mr. Hines pointed out, however, she's moving pretty slow. I mean, we don't see her running around at all. She's very slow, deliberate, I think is the word he used. I think that's a fair assessment. Should we make anything of that?
I don't think so. I mean, I think that the issue with surveillance is consistency, right? This isn't just one time. We don't have her on one day for 1 hour, doing things that seem to exceed her physical abilities that she's communicating to her doctor. We've got multiple days of it. We've got multiple different settings. She goes to Walmart, I think, on 2 different occasions. She goes to a garage sale. She's walking in and out of her house carrying, I think Mr. Hines and I would disagree as to, the weights. We have no way of really verifying it, but it looks to me like she's carrying multiple grocery bags in and out of her house. So while I think that it may be a deliberate, or she's maybe moving fairly deliberately, I do think that the consistency over a multiple number of days does evidence that she's doing things that exceed her physical abilities that she's communicating to her doctor.
Mr. Schmidt, something that we haven't discussed, and this is a two-part question. Did the judge make a finding of credibility? Because it sounds like what she's reporting to doctors and what we see her doing, there's some credibility issues, but did the judge actually make a finding on credibility?
She didn't make a specific finding. She didn't say specifically, I find the employee to be incredible. The finding that I think is probably most relevant here would be, sorry, let me just find that for you. Number 29, the employee's disability questionnaires and the difficulties she reported to Dr. Anderson are inconsistent with the physical abilities the employee demonstrated on surveillance videos on May 8th, 10th, and 16th.
And since it's not specifically a finding of credibility, how is this court bound by that finding then?
I mean, I don't know that the court is bound by that finding because it's not a credibility determination. I think it goes to the weight of the evidence that the judge examined when she made her findings in order.
Thank you.
I have a question. Is the statement that Dr. Maybot put in the September 9th, 2024 record where he says the incident increased the symptomology that the employee had, is that a causation opinion or something less or something more? How would you categorize that statement within the record?
I guess it is a causation opinion. I do take issue with it as a causation opinion and from a foundational standpoint. I believe there were some questions about this earlier. Dr. Maybot did not have all of the records. Dr. Wicklund, on the contrary to it, did have all of the records. Maybot didn't look at the surveillance, he may have treated her in 2012, but there's absolutely no mention in the record that he actually reviewed any of the MRI reports. We're not talking about like one MRI report. We're talking about neck, upper back, low back MRI reports that go back to 2012, and there's numerous of them, all outlined in the CDI. It's in the record and in the CDI notes. And there's no indication that Maybot looked at all those. He may have been aware of the employee from 2012 from prior treatment, but that's over 10 years ago. There's no indication that he's re-reviewed all of those to make any type of comparative opinions with respect to how her back has progressed during that time. So while it may be a causation opinion, I would not find it to be a strong causation opinion.
So with that, in terms of, if there were a causation opinion, it would still be up to the compensation judge then to weigh and balance and accept or reject any portion or aspect of any causation opinion, whether from Dr. Maybot or Dr. Wicklund. Would you agree with that?
I would agree. That's the Nord v. City of Cook case, I think gives the judge the discretion to do that. There's no other questions. I'll yield the rest of my time.
Thank you.
Thank you very much. I want to thank you both again for agreeing to do this in front of an audience. I know these are nerve-wracking enough, but to have to do it in an auditorium in front of students is another level. So again, thank you very much. With that, we are adjourned.